I'm going to be uncharacteristically controversial for me on this one. Bit of politics, as Ben Elton would say. But I want to talk about that incident in New York the other day, to put it mildly, where the executive of that health insurance company had a street encounter that did not go well for him, to put it in an algorithmically friendly way. But you've probably seen, if you've been looking at this story, that it's pretty fair to say people haven't exactly been sympathetic to the health insurance guy. So the question is, if they actually catch the, quotes, perpetrator of this, what's likely to happen to him? And I want to consider, obviously, from a legal perspective. Does he have any defence? And to cut to the chase, the answer is, it's a bit of a stretch, but he actually might. So let me explain. Like I say, I hope you've got the context there. Basically, the chap appeared to be waiting for this executive. He popped out, unalived him, as the kids would say. Now, interestingly, on the scene, he left 3 spent cartridges and 3 live rounds. And they were all inscribed with words, deny, delay, and depose, which is believed to be a reference to the tactics that health insurance companies use to avoid paying out people. And this particular firm that this guy was the head of, they have the highest record, the highest rate for refusing claims. It's about 32% of people who actually apply for them to cover a medical emergency get rejected. They actually use an AI algorithm that rejects about 90% of claims. I mean, the argument is that is flawed, and the company was involved in all sorts of dubious shenanigans anyway. So it's better to say they weren't very popular. And basically, most of the comments are people just explaining their horrible experiences in dealing with this company in particular and the American healthcare system in general. So this guy is currently a bit of a folk hero. But will that avail him if they catch him and they put him on trial? Well, first of all, where would he be tried? He'd be tried in New York. This is a state offence, so it's not a federal offence. So otherwise, Joe Biden might have had the opportunity to do something sort of quite funny and quite memorable. Of course, it's also open the state governor could pardon him, but that's the more politics side. What about the actual law? Well, let's say they put him on trial. There's obviously the issue just of jury nullification. Perverse verdicts, as we call them here. I mean, it may well be that a jury would just acquit anyway, just out of sort of sentiment. And there's not a lot anybody could do about that. You can't appeal a nullified jury, a perverse verdict, unless you can sort of show that the jury had been nobbled or tampered with in some way. But what about as a matter of law? Well, yes, there is, and I'd like to take you to Section 35.05 of the New York Penal Law. And I'm going to just read this to you, uncharacteristically, actually look this up, because obviously I'm not an American lawyer. I am very interested in American jurisprudence, and I do hope at some stage to have a video coming up with an American judge friend of mine, where we're going to do a compare and contrast to the sort of different legal cultures. So hopefully you'll find that interesting, but that probably won't be till next year, because he's not over till March, and as it happens, we'd arranged to meet somewhere, but I'd arranged to meet in May. But I'm sure we can sort it all out, how organised I am. But anyway, this section states, unless otherwise limited by the ensuing provisions of this article defining justifiable use of physical force, conduct which would otherwise constitute an offence, spelled with an S, 1776 and all that, I suppose, is justifiable and not criminal when, and subsection 2, such conduct is necessary as an emergency measure to avoid an imminent public or private injury which is about to occur by reason of a situation occasioned or developed through no fault of the actor, that's the potential defendant, and which is of such gravity that, according to the standards of intelligence and morality, the desirability and urgency of avoiding such injury clearly outweigh the desirability of avoiding the injury such sought to be prevented by the statute defining the offence in question. The necessity and justifiability of such conduct may not rest upon considerations pertaining only to the morality and advisability of the statute, either in its general application or with respect to its application to a particular class of case arising thereunder, Whenever evidence relating to the defence of justification under this subdivision is offered by the defendant, the court shall rule as a matter of law whether the claimed facts and circumstances would, if established, constitute a defence. So to break that down, what they are saying, it's not unlike our defence of necessity here, which is you can do something that would otherwise be criminal, regardless of whether you think the thing should be an offence or not in the first place. That's not the test, oh, this shouldn't be an offence. It's applying it specifically to this. But it's like, even if we accept that law is correct, I shouldn't fall within the ambit of the law because what I did was necessary, effectively, to prevent a greater harm. Now, interestingly, and I've looked into this, in England and Wales, necessity is a defence to every offence except the M word. And that all goes back to that case of Crown and Dudley and Stevens, you know, the one where they drew lots, rigged it, and ate the cabin boy. And at the time, most people said, yeah, that's a reasonable thing to do. You would all have died had you not done this, and, you know, why not eat the one who was going to die anyway? But that case, which is still good law, said, no, necessity is not a defence to murder. And that's cropped up in a couple of occasions. I mean, there were things during the Troubles where paramilitaries would force taxi drivers to drive them to places where they were going to carry out assassinations. And technically, the taxi drivers were accessories. And the mere fact they were being held at gunpoint was considered to not be a defence. Now, in practice, they tended not to prosecute the drivers in those cases, or sort of do deals with them and say, look, we know you got wrapped up in this, but if you give evidence for the prosecution saying who was in your cab, then actually we'll do a nolli prosequi, you know, we'll agree not to prosecute you anyway. And there was also that incident in the Herald of Free Enterprise situation where somebody froze on a ladder while people were escaping, so they had to pull them off the ladder and effectively just drop them back to their doom. So while technically that obviously was an offence, they said it's not in the public interest to prosecute. But in the US, and looking at the cases on this, where it's about lethal force, they said, well, no, the whole point of having the Second Amendment and allowing people to carry guns. I mean, obviously in New York, their gun rules are quite strict, but the Supreme Court said, no, you know, the whole point is we allow people to use lethal force. The one thing that is very clear is you can't use lethal force to just defend property, however valuable that property is. But we get into this thing, and this is the same thing here, as to, is whether you have a defence a matter of law or a matter of fact? It's a matter of fact, it just has to go to the jury. But they're saying, well, it's up to the judge to decide whether, even if we accept everything you say, that would amount to, you know, the defence. However, looking at some of the cases, it's very interesting. And I'm going to start off with a case, it was a non-lethal one, but basically it was protesters. And this was back in 1991. But again, this is a New York case, and there's some people who they were big fans of, you know, public transport, and they were saying that, you know, the transport infrastructure in New York was too car friendly, and that was creating a danger, not just of pollution and environmental impacts, but actually just risk of injury to pedestrians and cyclists. So they occupied Queensborough Bridge, and you know, they were all arrested for trespassing and public disorder. And when it came to the first instance trial, the judge said, well, I'm not going to allow you to run that as a defence. So that went off to appeal. And then they said, like, OK, the appeal court looked at this and they said, well, you know, it's an old common law thing, this. And interestingly, they adopted the English test. You know, 1, the actor has reacted to avoid a grave harm not of his own making. 2, there are not adequate legal means to avoid that harm. 3, the harm sought to be avoided is greater than that committed. New York also, though, has 2 additional requirements. First, the harm must be imminent, and second, the action taken must be reasonably expected to avert the impending danger. So the argument here would be, well, you make decisions that cost people lives, you know, as a sort of healthcare person. You refusing this, people, A, suffer for longer, because they're saying, there's this rather weird rule that this company had is, they had certain approved drugs, they had deals with certain approved drug manufacturers, and a lot of doctors have said it's really annoying because you could say this drug isn't suitable for this person, but before they could give them the drug that was suitable, they had to give them first of all the course of the approved drug and see if that worked, and say, well, no, people were really suffering. I mean, at worst they were getting no benefit from this unsuitable drug. But worse, it was actually causing terrible side effects. But even children were having to go through 6 months of treatment on a drug that the doctors didn't work, said wouldn't work, before the health company would say, okay, we will now allow you to use the one that's not from one of our preferred suppliers. But yeah, is it an imminent harm? I mean, normally the situation is the classic one. Literally somebody is there trying to harm somebody or pointing a weapon at somebody, and you act. Well, there's no, it's fairly clear there that is imminent harm. But is something like this, like denying healthcare, is that that imminent harm? But anyway, in this particular case, they actually said, because they have this idea of sort of the balance of evil, which I think is a great, it sounds like an Orson Welles film, doesn't it? But what they said there was, look, it's a pretty low threshold to let something go to the jury. So whatever the judge may think of it, fundamentally, if the defence can actually raise evidence to satisfy each of these limbs, then you should really let it go in front of the jury. And once it's in front of the jury, it's for the prosecution to disprove to the requisite standard, which in New York is beyond reasonable doubt, that they weren't acting through necessity. So it puts the burden back on the prosecution. So all you have to do is sort of raise. You can't just say, we say we're acting through necessity, you prove we weren't. You have to say, right, this is why we say we were acting in necessity. And you just have to raise the issues and sort of give some factual background. But then there's no evidential burden on you to prove it. Now, the other interesting thing is, it becomes almost, your actions have to be reasonable, but is that subjectively reasonable or objectively reasonable? Is it what you personally think is reasonable, or is it what your average person would do? And it's a bit of a mixed test there. I mean, the first thing is, you don't have to show that your actions would actually be effective. They said, it's not, to get to this end, you'd have to show, now because of what you have done, suddenly, all of a sudden, health companies have started being reasonable. Although people point out it's very interesting that there was another controversial decision about companies were only going to pay for anaesthetic up to a certain time in the operation. And if the operation took longer, they withdrew the funding for the anaesthetic. And they very much reversed that policy, I'm sure, purely coincidentally. There's another interesting thing where a healthcare insurer has put out a thing saying all their employees have to sign a pledge saying that they accept, they recognise and acknowledge that health service executives are wonderful people and do a great job. And they abhor any criticism or harm to them. I mean, whether or not they are obliged to sign that, that's probably a topic for another video. But in this particular case, they said, no, once they actually have shown that there's some factual basis for this, it goes in front of the jury. And what's interesting is, in a majority of cases where necessity has been left to a jury, they actually have acquitted. But obviously this was just blocking a bridge. So, that's obviously not involving the use of anything lethal. But the other one I could find on lethal stuff was an interesting one where a guy got into a bit of a sort of road rage incident and the other person pulled a gun on him. Now, this guy, he fled the scene to get away from the shooter. But at the time, he'd been drinking and he also drove at excessive speeds. He actually ran somebody over and took them out. And he was convicted because they said there, well, no, this doesn't amount to necessity. It's all your own fault because whatever happened, you were out drunk in the first place. And also they said there's no evidence that the person even, had a gun. You may have overreacted. But the court there said, well, look, the appeal court said, we're not going to rule on, whether or not he is guilty or not. But what we are going to say is we're going to send it back for a retrial and you have to allow him to run this defence. So there you go. So that was, the use of, somebody ended up unalived, but they said you can run necessity. And, the great harm you're preventing there was the risk of this person who you say had a firearm shooting you. So in this particular case, yeah, I mean, it'll be very, very interesting to see what happens. We're obviously speculating, and I'm not suggesting, at this stage, anybody's done anything wrong. I mean, I suppose it's a bit obvious that somebody might have prima facie done something wrong, but, just to cover myself. It's interesting now, would this guy be a public figure for the purposes of defamation? Because there's this argument that you should only be a public figure if you voluntarily put yourself out there to be a public figure. Because you can be a public figure just on one narrow issue. So say if you're some celebrity or some politician, you're a public figure, whatever, for everything. If, however, you're just an ordinary Joe public, you can be a public figure on a particular topic. This was with the Alex Jones thing with the Sandy Hook families, and it was an argument as to whether, because they had spoken publicly about the event, they were public figures and therefore you had to apply the malice standard. Now that never actually got tested in the end because Alex Jones didn't file a defence. He didn't acknowledge do acknowledgement of service in time, so this was never tested. But the argument there was, well, while you would not be a public figure for defamation generally, on this particular topic you are. So, is going out there and doing something like this, does this make you a public figure? I'm not really worried about him suing me or her. But yeah, so there you go. I mean, it's going to be an interesting one, that, because if this does go to trial in New York, bearing in mind what appears to be the motive for this, will they be able to raise a defence of necessity? And it's interesting because I think the more health companies suddenly revise their policies, then arguably his defence becomes stronger, because it's like, well, I can show now that doing this one act, as terrible as it may seem, although not on social media, people, there's got a lot of jokes out there about it. Now they've done that. If they turn up with some actuaries and say, as a result of these companies changing their policies, X thousand people who would have otherwise have died or suffered now won't, then arguably that really bolsters the defence. But anyway, we shall see what happens with this. I mean, they've got to catch him first, haven't they? They did cycle on the pavement, so I wonder if that would fall within the within the ambit of the necessity defence. But there you go. As always, hope you found that vaguely interesting, vaguely informative, vaguely accurate. I mean, I'd just genuinely be interested in your comments here, both about what happened sort of generally, and this law in particular, both as it will apply in New York and also as it applies generally. I mean, I've mentioned before, I've done a video, you can search it. I've done a couple of videos actually on necessity and breaking the law and when that can be justified. So I never do all the, if you want to go and look for them, feel free to find them. But yeah, there you go. As always, the boys, they're still on their shelf. You can probably hear in the background there's a generator rumbling because we've got a big storm down here, so we're actually running off the generator at the moment. So I probably shouldn't have all these lights on because I'm probably hogging all the power from all of us who are sharing the generator. But yeah, see you next time. Oh, right, now which side do I need to sit on? I always get this wrong, so I'm just going to sit on this side first of all, just to get a thumbnail picture. And then just in case I'm wrong, which I usually am, I think it's actually this side that I have to sit on. There you go. I'll probably not end up using this because this being like quite a interesting subject, I'll probably do one of my things and ask Dan to do a thumbnail for me. Because whenever Dan does my thumbnails, I always get like loads more views and likes and subscribes and things, because I never ask for those, as you know. And like I say, I'm quite happy. I'm just grateful if you actually, sit through all these, especially when, as now, I am rambling.